Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Chad Michaelson, a Pennsylvania construction lien law guru. So today's webinar topic is what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the wonderful Chad Michaelson.
Thank you very much, Jessie, for that nice introduction. I very much appreciate it. Welcome everybody today to talk a little bit about using mechanics liens to get paid in Pennsylvania. Jessie, if you want to go to our next slide. Yeah, we have a chat box here in the webinar, and so if you want to put your questions in there, we're happy to answer those at the end. And as the slide here notes, don't include any kind of specific information, names or company names in the questions. So what's our agenda today? Well, there are a number of things you can do to ensure that you are paid after you filed a lien. These are essentially the kind of 6 things I want to try to cover. There are a number of strategies you can employ and people that you can look to try to leverage your lien in order to actually turn that into dollars. So let's start with the first slide, which is how do we use that lien to pressure the owner to pay you? Next slide, please, Jessie. The real idea here by filing a lien is to be the squeaky wheel. It's to be a problem for somebody other than the general or the sub that isn't paying you, or the owner, depending on what position you're in. So you, by filing a lien, now have claims against somebody else who has to deal with you. And so you want to make their life difficult so that they either pay you or they put the appropriate pressure on the general or the sub to pay you. So that is the real effect of a lien. A lien gives you the legal right to demand payment from the owner of the property that you improved. So you shouldn't be afraid to exercise that right. Simply filing a lien puts them on notice, but the lien itself, as we'll talk about later, doesn't entitle you to payment. The lien has to be turned into a judgment before the owner actually has to pay you anything. So you need to threaten the owner with those kinds of remedies, that you will turn the lien into a judgment, or that they know you're serious so that they'll either take care of it in order to lift the lien from their property, or they'll force the contractor to take care of it. And that's the second point here, that you filed a lien, and although you don't have a contract with the owner and they have to pay you, but they have the right to seek payment from the contractor if they pay you, or they have rights to force the contractor to pay you. Under Pennsylvania's mechanics lien law, the owner is allowed to pay. First of all, the owner is allowed to withhold payment from the contractor when a lien is filed. So that alone should create additional pressure, because now the contractor, if you're a sub, the contractor that you've contracted with isn't getting paid. And on top of that, under the mechanics lien law, the owner has the right to actually pay your lien and to then take that money back from the contractor, either by withholding or by suing them. And the owner has the right to collect attorney's fees as well. So you should know when you file a lien that you have rights against the owner, and you should enforce them against the owner. Don't just file a lien and say to the contractor, hey, look, I filed a lien. Use your lien rights, go after the owner. Typically then, the last thing I'd mention here is that when you are dealing with the owner, any kind of savvy owner is going to want to pay you with a joint check. Understand that, when you are in the owner's position or the GC's position, you can't pay somebody directly that you don't have a contract with. By doing that, you open yourself up to liability for the whole contract. In addition, if I'm an owner and I directly pay a subcontractor, then the general contractor can look at that and say to the owner, that doesn't count as payment to me under my contract, because you wrote this sub a check. It's my sub. You don't have a contract. I didn't tell you to write them a check. Therefore, the general could try to force the owner to double pay. So joint checks are used in that situation. And joint checks are simply a check made out to two parties that the general and the sub have to both sign. So that's an appropriate way to receive payment. You shouldn't be afraid to do that. It's really more of an issue for the general contractor or the owner than it is for a sub. All right, so next slide, please. The other thing to think about is, yes, I have a lien, but I still have to enforce all of my rights against everybody I can in order to get paid. So don't forget about making bond claims, because in Pennsylvania, if a payment bond has been posted, there is a way to waive subcontractor lien rights in advance so that you might not have lien rights. And if you file a lien and the owner or the general contractor says, nope, you can't file a lien because your lien rights were waived, there's a no lien agreement on this project, then your remedy is the bond. Sometimes you have a bond and the right to lien. So don't forget about the bond. And in order to make sure you can protect those rights, you always want to get a copy of that bond up front. It's much easier to do it at the beginning of the project than it is when you're not being paid. And it's very important to have a copy of the bond because there are terms in there you have to comply with, otherwise you lose your rights. One of the primary ones is that there is a time limit in every bond for how long you have to file a claim after you've finished your work, or after the debt has accrued, depending on what the bond says. In a lot of cases, that's 1 year, but sometimes it's less. So you have to be careful that you are putting the surety, the bonding company, on notice of your payment claim in a timely fashion. Otherwise, you could lose your rights. You also, when you make your bond claim, need to look at the bond and see what it requires you to submit. You need to provide backup to the bonding company. If you simply send a letter that says, I'm owed this much money, you'll get nowhere. They'll send you a packet and ask you for information in order to substantiate your claim. So you're better off to prepare your claim, to back it up with your payment applications, to back it up with certified payrolls or whatever you might have to establish the value of the bond claim. Next slide, please. So then, after you've filed your lien and pressured the owner, after you've made sure you've asserted your bond rights, don't forget to continue to enforce your contract against the general contractor or the sub that's not paying you, or the owner that's not paying you. Because the lien law gives you the right to recover the value of the labor and materials that you provided. It doesn't allow you to recover anything else. And if you have a contract, for instance, that says that you're entitled to 12% interest per year, you won't be able to recover that on a lien claim. You need to sue the owner or the general or the sub, whoever hasn't paid you. You need to sue them under the contract in order to get those additional remedies. So again, if your subcontract says that you get interest on late payments, you have to sue to get that. If your subcontract says that you're entitled to attorney's fees if they don't pay you and you have to sue them, you have to sue to get that. You won't get that on your lien claim, which is not to say you shouldn't file a lien. The lien creates good leverage, but it doesn't give you the right to all your money. In addition, you should be pursuing the contractual dispute resolution mechanisms, right? Putting pressure on whoever you have a contract with to pay you, and you have to follow whatever the contract says. Many times it'll say you have to go to mediation first, but if not, it might describe whether you go settle your claims through binding arbitration. And if you do that, who are the arbitrators and how do you start that? Or it might say you have to resolve your claims in litigation. And if so, where do you file the litigation? So you will be in a position, and you should be in a position, where you might have to actually file 2 lawsuits. One lawsuit is your contractual lawsuit seeking all the remedies available to you under the subcontract against the person that hasn't paid you. The second lawsuit is going to be a lawsuit to enforce your lien claim. And that's what we're going to talk about next on the next slide. I hope. It might be the 5th slide. We'll see. Oh, there it is. So again, after you've done these things, after you've filed your lien and notified everybody and pressured the owner, after you've made sure you've enforced any bond rights, after you've taken the steps you need to sue under the contract, In order to turn your lien from a piece of paper into dollars, you need to convert that lien into a judgment. And the way that's done in Pennsylvania is by filing a complaint. You file a lawsuit. You initiate a lawsuit on your lien where you will be required to go into court as the plaintiff or the claimant and prove that you provided the labor and materials that are in your lien. You will need to prove the amount of your lien. There is a 2-year deadline to do that. So if you file a lien on a project within 6 months after your last date of work, if you're a general contractor, within 5 months, it's still 6 months for a sub, but you have 5 months to give your initial notice and then 6 months to file. If you've done that, then you have 2 years to file a complaint. If you don't do that, then your lien goes away. So you have to file a complaint to prove your claim and turn it into a judgment. Now, again, as I said before, that complaint is only for what's recoverable under the lien law. It's just your labor and materials. It can't include attorney's fees that are due under the contract or interest that is due under the contract or any of your available remedies under the Contractor and Subcontractor Payment Act, CASPA, which we're going to talk about in a second. So you have to, it makes sense to convert your lien to a judgment. And the reason that the 2 separate lawsuits make sense is because if you're a subcontractor, your contract lawsuit is against the general contractor, seeking all those remedies under a contract, trying to get them to pay you as they should have. But your lien lawsuit is against the owner of the property. So it's not 2 completely duplicative lawsuits. It's 2 lawsuits against 2 different people in 2 more ways to get paid. All right, next slide, please. So I want you not to forget about CASPA. CASPA is available to subcontractors, subcontractors, general contractors in Pennsylvania as a remedy for non-payment. It's a very powerful statute. It provides for 1% interest per month or 12% per year if you're not paid in accordance with the terms of your contract. So that's required. Simple non-payment entitles you to 12% interest unless you agreed to something different in your contract. If you agreed to less in the contract, then that's the interest rate that will apply. But if you didn't agree to anything, CASPA allows you 12% per year, 1% per month. CASPA also says that if you have to sue in order to recover sums that were due under a contract, and that they were withheld in bad faith, you can get another 1% per month or 12% per year. So a true bad faith withholding of payment is subject to 24% annual interest under Pennsylvania law. That's pretty good. Also, CASPA allows you to recover your attorney's fees if you're forced to sue to recover amounts that were wrongfully withheld. The other important thing that you'll find in CASPA is that CASPA has a provision that requires a party that's supposed to be paying you money to notify you of any good faith basis for withholding payment, any deficiency items they're called, within 14 days of the time they receive your invoice. If the owner or the general fails to do that, CASPA says that they have completely waived any right to withhold. So you don't, even if they contractually could have withheld, even if you have defective work, that CASPA says they waive the right to withhold if they don't give you written notice. In addition, CASPA says that they have 10 days to notify you of a defective invoice. So if they don't like the support or if there's an error in your invoice, there's only 10 days for the owner or the general or whoever owes you money to tell you that in writing. If they don't, they waive that. Those are very powerful remedies. And so you want to make sure you're paying attention to those. But again, this is a point I made earlier. CASPA remedies aren't available as part of your lien. The CASPA remedies are only available against the party you contracted with. This is why in Pennsylvania, you will end up bringing 2 separate lawsuits. The good news is that under CASPA, if you recover, you can get your attorney's fees for bringing the lawsuit against the party that you had a contract with. Unfortunately, you cannot recover attorney's fees on your lien claim. So that lawsuit and the costs you incur to pursue that lawsuit will be on your own dime. So I think that might be our last slide. Let's see, is there one more? Ah, I knew there was one more, okay. Now, I've gone through 5 ways that you can exert pressure in order to get yourself paid, right? You don't actually want to have to file a lawsuit. That costs money, that takes time. What you want is for your lien filing to let people know that you are serious and that you will do all those things if you don't get paid. So the real goal is get paid. So how do you ensure that you get paid and that you don't waive any rights? Well, we go back to accepting joint checks, right? Accepting a joint check from the owner doesn't waive any of your rights. Now, if it's a partial payment, okay, you have to be careful. You can accept a partial payment. You just can't sign anything that says that it's full payment. Most owners, most contractors will require you to submit some kind of release in exchange for a joint check. If it's a partial payment, that release needs to be really clear that it's a partial payment only, and you are only releasing your lien rights with respect to the dollars in the check that you received. So you want to be really careful about anything you sign in addition to receiving a check. But if you just receive a check and the check doesn't say on it anything like full and final settlement or final payment, it's just a check and it's not the full amount of your lien or the full amount of your claim, you're probably not waiving your rights. But again, look at those releases. Not only do you want to look at the amount of the lien release they give you, but you want to read it, because you should only be releasing your lien rights with respect to what you're paid. You don't want to release any other rights that you might have against the contractor. So think about that. Here, the owner is paying you and getting a release from you, and the only rights you have against the owner are lien rights, so that's all you should release. But owners will often give you a release that says, I release all of my claims for payment, which might mean you're releasing your claims against the contractor, which would include releasing your CASPA remedies and all these other things I talked about. So be very careful about any release of liens you're given. You have to look at those carefully or consult with a lawyer. And that last point about promises to pay, you also have to be very, very careful with promises to pay. This is particularly sensitive when you're waiting or with respect to these lien deadlines. I know a lot of people file notice of intent to file a lien, they get a promise that they're going to be paid, and they wait and they let the 6 months run and they lose their lien rights. Do not accept promises to pay unless it's in a written instrument like a promissory note, right? Then you actually have a new enforceable promise. You have a new contract from the person that gave you that promise, and you won't have a claim against the property, but you have a different way to recover. So don't waive your rights. Be careful when you receive payment. Next slide. That's it. Lots of strategies, lots of ways to get paid.
Yeah, thank you so much, Chad. You really are incredible. That was a lot of really great information. I cannot reiterate exactly what you were saying. Please read your releases. If somebody is giving you a release to sign, most likely it's going to have language in there that's going to protect them, not you. So read what you guys are signing. When in doubt, you can always provide a release through our system, and we have that conditional language on there that will protect you. All right, so we do have a couple of questions that have come through. And it says, are there differences in the process for sending preliminary notices or lien laws for residential and commercial?
There's no differences in terms of the notices. There are significant differences in terms of whether you can file a lien. So no lien agreements are easier to have on residential projects. And so in that case, you really do want to be able to find out whether the owner and the general contractor agreed to a no lien agreement, because it's easier. On commercial projects, there is no waiver of lien rights unless there's a payment bond posted, right? And since the general contractor posts the payment bond and can't recover under it, a general contractor can never waive lien rights in advance in Pennsylvania. So here, you know, commercial jobs, it's easier. Residential jobs, I'm sorry, I got that backwards. Commercial jobs, it's harder to waive. Residential, it's easier.
Okay, wonderful. And then this is going back to something you said in your presentation. If the owner disputes your invoice within the 10 days, as you said, are they sending that certified mail? Is it being recorded?
Good question. It just needs to be written. There's no certified mail requirement. There's no requirement in Pennsylvania that things be, you know, lien releases be notarized or that anything be sent certified mail. The requirements you have are the requirements for serving your notice of intent to lien and serving your lien. Those are very, very specific, and you need to make sure that's done exactly right and in a very certain time frame. So that's a really important point and something you really need help from a lawyer or you call SunRay for, because you don't want to miss out on those rights.
Okay, and then kind of a follow-up question to the owner disputing the invoice. It says, how long do you then have to respond? Does that change my deadline?
That depends on your contract. So the CASPA doesn't say how long, but you really want to obviously get paid as soon as possible. So you resubmit, you correct, and then that clock starts running again, right, for the owner. So they get a proper invoice, and if there's still a problem, the 10-day clock starts again. So resubmit your invoices as quickly as you can.
Okay, wonderful. And then I think this is the last question. It does have a couple of parts to it, so bear with me. It says, I'd like to understand the entire preliminary notice process in Pennsylvania. Do you have to do an online notice if you have a direct contract with the GC? And is it absolutely mandatory to do an online notice?
So the online notice is only required for what's called a searchable project, which is a project that's valued at over $1.5 million and listed on the state construction notices directory. So if you get in a project that is of that size, you should go online, you should search for that project, and if it's on there, you must file your notice of furnishing in order to protect your right to lien. If you don't, and you do it later, you lose your lien rights with respect to anything prior to your notice of furnishing, but you could still pick up lien rights if you filed that somewhere midstream in the project. So it's absolutely mandatory. For projects that are not listed in that directory, there is no online registry that applies. There is no notice of furnishing that's required to be filed. The only thing you have to do to protect your lien rights is give notice within 5 months after your last work, your preliminary notice. Within 5 months.
Okay, wonderful. And kind of a follow-up question to that. What makes the general contractor required to do an online notice of NOC?
The general is never required. It's the owner's option to do that for their project in order to gain some additional lien protection and some visibility into the subs that are working on the project. So typically the owner decides that and maybe has the general contractor file the notice for them, but it's an owner decision whether they do it. And it's really easy because there's no cost. You just simply register the project and you're done, and then your subs are going to have to be filing the notices of furnishing. So it's the owner's decision usually.
Okay. All right. Wonderful. That does appear that that's all the questions that have come through. If anyone does think of another question, please feel free to reach out and I'll be sure to answer any questions for you. All right. So on this slide, if you are able to scan that QR code, these are some of the SunRay resources to help you stay organized, know your deadlines, secure your lien rights. Please remember that each and every state has its own unique set of lien laws, deadlines, document types. So please go onto our website, check that out. It will help make sure that you guys are protecting yourself and the projects that you are a part of. There's SunRay project information sheets on there that will help you kind of obtain the information early on in your project and asking for those bonds, asking for some of the documentation and who's working upstream from you, so you know the ins and outs and all the entities involved. So please check that out. All right, let me get to the next one here. Our next webinar with Chad is going to be Getting Paid Faster with Liens, Bonds, and Contracts. That's going to be July 16th at 10 a.m. So please register for free at sunraynotice.com/education. We'd love to be able to see you there. All right, and then if you don't mind, take a moment to give us a review on Google. We'd really appreciate that. It takes about a minute of your time, but it helps other contractors like yourself to hear about us. And we really do appreciate all the feedback that you can provide to us. It helps us better ourselves. And with that, that is all we have for you guys today. Thank you so much to everyone that attended. We hope to see you at our next webinar. Thank you again, Chad. You really are incredible. I hope everyone has a beautiful and wonderful sunny day. Thanks, everyone.